Good afternoon, Your Honour. My name is Mudassara Naska and I'll be representing the defendant, Ms. April Morris, in this bail application today. Ms. Morris was arrested at 10:30 a.m. this morning and has since been remanded in custody by the Victoria Police. She was charged with the following: common assault under Section 23 of the Summary Offences Act 1966 Victoria, causing injury intentionally or recklessly under Section 18 of the Crimes Act 1958 Victoria, persons found drunk under Section 13 of the Summary Offences Act 1966 Victoria, willful destruction, damage, etc. to property under Section 9 of the Summary Offences Act 1966 Victoria. Your Honour, I would like to firstly begin this application with a bit of background on my client. Ms. April Morris was born in Melbourne and is aged 27. She has a bachelor's degree in marketing at Victoria University and is in a senior position at her company. She is currently in a same-sex relationship with her partner of 2 years, Paulina, and they are currently living together. Ms. Morris has not spoken to her parents in 2 years because of this relationship, as they do not agree with it. Ms. Morris makes $125,000 a year, so she is financially stable and can support their relationship. Ms. Morris can be described as an easygoing, bubbly, and friendly person by friends and colleagues, and she can be identified as a hard worker and easy to talk to, and she is seen as a valuable asset to the community. Ms. Morris also has shares of over $75,000 and savings of more than $50,000. Ms. Morris also has her commercial pilot's license, which makes her a qualified pilot and highly employable to prospective employers. Ms. Morris also has a black belt in Zendo Kai, having practiced the style for the previous 4 years. She is also very active on social media such as Instagram and Twitter, and she can be regarded as an influencer. Ms. Morris likes to attend rave parties, nightclubs, and likes to socialize on her weekends. She usually does this with her friends and her partner. Your Honour, it is important to note that Ms. Morris has a minor blemish on her record, which is driving while suspended, which was 5 years ago now. But there has been no convictions recorded. With these factors in mind, I would like to refer to Section 4 of the Bail Act, which states, unless my client is required to show compelling reasons or exceptional circumstances, then she will be granted bail. Your Honour, this presumption applies to Ms. Morris's case as her offence does not fall into either a Schedule 1 or Schedule 2 offence. Your Honour, the prosecution argues that my client is an unacceptable risk under Section 4E of the Bail Act, which states that if my client was released on bail, she would endanger the safety of the community, or that she will commit an indictable offence whilst on bail, interfere with specified witnesses, or that she will obstruct the course of justice in any matter, or that she will fail to surrender into custody in accordance with her bail conditions. The burden lies with the prosecution and those opposing bail. Here it is important to take into account my client's surrounding circumstances. Under Section 3 AAA subsection 1 of the Bail Act, these include the nature and seriousness of the offence, the strength of the prosecution's case, and the accused's criminal history. Other factors that I have not mentioned pursuant to Section 3 AAA subsection 1. Under the Charter of Human Rights and Responsibilities Act Victoria, my client has the right to freedom of movement. Under Section 12, which states that every person in Victoria that is lawfully in Victoria has the right to move freely within the state, including entering and leaving it. Being considered an unacceptable risk would deny my client of this right. Other relevant sections include the right to take part in public life under Section 18, the right to liberty and security of a person under Section 21, the right to a fair hearing under Section 24, and lastly, the right to humane treatment when deprived of liberty under Section 22. Based on the evidence produced by the prosecution of my client's alleged offence, I do not believe my client should be denied bail under Section 4 of the Bail Act. The prosecution produced evidence of 2 witnesses who saw the alleged assault on the victim, Ms. Kendall. And secondly, Ms. Kendall's medical records indicate that she needed 9 stitches to the forehead, bruises, and abrasions. Ms. Kendall states that she is traumatized by the event. However, when Ms. Kendall's injuries were sustained, my client was highly intoxicated and under the influence of alcohol, and she cannot remember hurting anyone or damaging any property. Therefore, it is evident that Miss Morris acted out of recklessness rather than intention. She did not form a premeditated intention to hurt Miss Kendall as she was intoxicated. Your Honor, I find it hard to believe that my client would be deemed an unacceptable risk to society as she has no relevant prior convictions. And given her warm and friendly nature, she does not pose a threat to society. Your Honor, the prosecution stated that my client's childhood friends were affiliated with gangs and one of them being a president is irrelevant to this bail hearing as Miss Morris has not contacted any of those friends in the last 15 years, as she no longer associates with them. Most of her free time is spent with her partner and her friends. Another point that was raised by the prosecution was that her relationship with her parents is severed due to her criminal activity and that they perceive her as a criminal. This is false. As mentioned before, she has not spoken to her parents due to her relationship. Miss Morris's parents would not agree that their daughter is a criminal and she is capable of hurting people, given that she is so easygoing and polite. Your Honor, my client only has one minor blemish on her record, so how can she be deemed an unacceptable risk to society on the basis of one reckless mistake? Your Honor, I request the prosecution to drop the charge of common assault as it overlaps with the charge of causing injury intentionally or recklessly. This would be a miscarriage of justice, as charging her on both counts would constitute double punishment. My client agrees to plead guilty to the charge of intentionally or recklessly causing injury. Your Honor, my client agrees to visit a designated police station twice a day whilst on bail. She agrees not to post anything in regards to her bail or her hearing on social media and will not attempt to contact the victim under any grounds. She also agrees to hand in her passport and her commercial pilot's license. And lastly, she undertakes that her partner Paulina will act as a surety for the deposit amount of $50,000 if she fails to show up to her next hearing or breaks any of her bail conditions, if this be necessary. She will even compensate Miss Kendall for the damages. Your Honor, I believe my client Miss Morris will uphold all her bail conditions, given that she has no relevant prior convictions. Miss Morris has expressed deep remorse and is very regretful for her actions towards Miss Kendall, and she will do anything to make things right by Miss Kendall. Thank you for your time today in hearing this bail application, Your Honor.